Hey friends, come on in. We're running a little late today for today's live Q&A session. It's Monday, July 1st. Welcome to the month of July. It's nice to be with you. Come on in, type in freedom now, freedom now, freedom now, and let me know who is watching and where you're joining from. Friends, we have moved. We're still in White Plains, but we've moved several blocks down the road. And we have a lot of logistical things that we were working on earlier today to get our new office set up for you. As a matter of fact, we even had some walk-ins this morning at our new location. So if you're in the White Plains area, New York City area, Long Island area, it's a great opportunity to come on in, meet with us, attorneys, and have your consultation and see some of our team. Thank you guys so much for being with me. I see that folks are on. Freedom now, freedom now, freedom now. Welcome, everyone. My colleague Sonia is also in the chat. Okay, so she is going to answer some questions about how to get started with us or how to book a consultation. Sonia is in the chat, and she's also going to be moderating, okay? And so we're asking that you do not spam. If you spam, Sonia will put you in timeout. Type in freedom now. Let me know where you're watching from. I see that Lagos, Nigeria is in the house, New York City. Hey there, Patricia. Thank you so much for being with me. Miguel, hey there. How was your weekend? Did you guys have a good weekend? Oh, it is hot here. It is so hot in the New York area. Hey there, Grace. Nice to see you. Thanks for joining. And I see Mal is on from Philadelphia. Our office is open, friends, of course. We go deeper with you during a consultation to discuss your immigration problem or possible strategies that you may have, right? So book a consultation with our firm today so that we can help you understand what's going on with your case. And if there's a way forward, we would be happy to be the ones to help you move forward. Hey, Jermaine from Tucson, Arizona. Thanks for being with me. Give me some hearts and likes as well. And guys, subscribe to our newsletter. If you have not yet subscribed to the #1 immigration newsletter, subscribe today, mcbeanlaw.com/subscribe. Yesterday, we shared a terrific success story involving one of our clients who has a very serious background. We discussed it in our success story about how she obtained her green card through a spouse. And unfortunately, within 5 years of being a green card holder, she committed a very serious crime. And this crime, although it was classified as a misdemeanor, it did come with some very severe immigration consequences. And she was unaware of those serious consequences. And later on in life, she applied for naturalization. And when she applied for naturalization, it was at that point that the government became aware of the background, and then they placed her in removal proceedings, and a judge stripped her of her green card. Her green card was revoked, and this is the situation that she was in before coming to us. And we worked with her on a U visa case and got the law enforcement agency to certify her case. And so now it is she's on track for the U visa process to obtain lawful status, and then ultimately down the road to get her green card, have her green card, be a resident again, okay? So read that success story if you have not yet read it. Now let's get into some immigration questions. Yancy is asking, how long does USCIS take to make a decision after an interview has been waived? That's a great question, Yancy. It depends truly on the type of case that was filed with USCIS. If they have waived your interview, they are looking to move your case along much faster. But my question to you is, how do you know that your interview was waived? Did they notify you that your interview was waived? Or is it because some time has passed and you've not been interviewed or hadn't gotten an interview notice, which makes you think that your interview has been waived. In any event, however you were notified of it or think that it was waived, the timing of the process and really truly depends on the type of case that was filed, and then how fast they're adjudicating that type of case at the local level. We have been seeing some fast approvals this year for cases that have been filed this year since January in marriage cases, adjustment of status cases here in the United States. We're seeing 3 months approval, 4 months approval. The agency has been hiring more people, they've said, and they are waiving still a lot of interviews and then calling some folks back in. So truly, it really depends on your case. Freedom now, freedom now, freedom now. Let's go with your immigration questions today. Thank you so much. Someone says, I wanted to thank you. I have been following your post for years, and currently my spouse and daughter will be coming to the U.S. in August. Well, congratulations. That's terrific to know. Thank you, Michigan, for being in the house. New Jersey, Florida, Buffalo, New York, San Antonio, Texas. Let's go down to some questions. Someone is asking, is it true that you can file for a green card if you have certain jobs like healthcare? So if you have a job offer, then an employer can file a petition on a labor certification on your behalf, and you could get a green card through an employer. If you're here in the United States and you've overstayed your visa and your employer is trying to do this process for you, you will need a waiver, and then you'll need to go back to a U.S. embassy back home for an interview to complete the process. But everyone else who is in status, whether they're in status here in the United States or abroad, they're able to successfully go through this process, whether they're in healthcare or they're in tech or they're in hospitality industry. It just depends on the good job offer that you've gotten and your employer's qualifications, as well as your qualifications for that job. All right. Freedom now, freedom now, freedom now. California is in the house. Thank you so much. Someone is asking, Shakira wants to know, can people with a removal order be eligible for PIP, parole in place, which is the new process for spouses of U.S. citizens that the Biden administration has rolled out, or they're still rolling out the details, I should say. For PIP, and I've talked about this a couple of times during live sessions, you might have missed my answer in which I said, yes, an individual with a removal order can be eligible for this new and wonderful opportunity. But the way that they will have to go through some different phases in order to be successful here. Firstly, they would need the PIP approved. They would also need an I-130 approved through the spouse, U.S. citizen spouse, after which they would need their immigration court case reopened, because you're talking about someone here with a removal order, so they're not in active removal proceedings any longer, so their case will need to be reopened. And if prosecutorial discretion is still around, by the time you've gotten through PIP approval, I-130 approval, then it's possible to take your case to DHS ICE with a request that they join with reopening your case. If they approve that, terrific. Then your case is reopened in court and terminated. Then you could finally apply for adjustment of status, which the administration has said you must do within the 3 years of having that PIP status, so to speak. So it is possible. You will need legal help for this, and we do this process. We will be doing it for PIP eligible folks as well. So you can reach out to us for more details about this process. We're accepting consultations for PIP. Thank you so much. Freedom now, freedom now. Pennsylvania is in the house. Thank you very much. Someone is asking, Francesca, my I-130 was approved 5 weeks ago. Great. My I-485 was approved 3 days ago. When will I receive my green card? Any day now. They're fast with it. We have not, at least I have not heard any of our clients having a delay with getting their green card after the I-485 was approved. So it usually happens very quickly, within a matter of days for most people, okay? And I'm not saying that it will happen that way for you, Francesca, but I'm just letting you know that's what we've been seeing. Happy 4th of July weekend, everyone. Thank you for that, Fox 21, for reminding us that it is a holiday week. Some of us Jamaicans, we work a lot. So sometimes we don't even realize when there's a holiday coming up. We didn't plan anything for it. We work, work, work. But it's great to rest. Thank you, thank you, thank you. How much is our consultation fee? The consultation fee is $250 for attorneys at our firm and $300 for me. Hey there, Anne Marie in Florida. Patricia, hearts back to you. Freedom Now, Freedom Now. Thank you. Let's see. Someone is asking a question about the 212 approval for deportation and the 601. Can they deny me the visa at the consular appointment for deportation, or should I not worry about it having the 212? You know that too. Jersey, you have some serious immigration steps that you're walking through, and with the 212 approval, that's a great step in the process to get that permission to re-enter the United States. But the consular officer will still look at your immigration record. If you have a 601A or 212 approved, or 601A and a 212 approved, it satisfies the burden related to the problem, okay, with those particular waivers. However, the embassy official will need to assess everything else about you to make sure that you're eligible for the immigrant visa. And if there is any lingering issue that is an inadmissibility issue, that wall that stands between you and the visa, the immigrant visa, they will mention that to you and give you an opportunity to cure that problem through the I-601 waiver, which you can only file if you're interviewed at the embassy and they make that determination that you need the 601 waiver. So work with an immigration attorney. If you don't already have one, reach out to us so that we could tell you what's ahead, so that you'll be able to plan accordingly, and so that there are no surprises at the U.S. Embassy level. But it sounds like you're getting closer to your freedom. New Orleans is in the house. Thank you very much. Thank you very much. Thank you. Freedom Now. Adam says he recently applied for TPS. If I apply for advanced parole and travel, do you believe I could be denied entry since I overstayed for 3 months? I overstayed for 3 months before I applied for asylum, pending since 2019. So you have an asylum case pending since 2019. You also you've applied for TPS, and now you want to apply for the advanced parole and travel. If you are granted the advanced parole, that's fine. You can travel so long as you do not travel back to that country, your home country, because you have a pending asylum case. Being denied entry with your advanced parole, that very rarely happens. I've never seen that happen, at least not to any of our clients. Normally with the advanced parole, you are able to come back into the United States. So I think you should be fine, but definitely you may consult with us about your background to get another fuller opinion about your situation. It's hot in Atlanta, hot Atlanta. I know. It's really something all across the U.S. Thank you, Freedom Now, Freedom Now. Thank you, Freedom Now. Natasha wants me to talk about the Muno's case, the Supreme Court case, right? Does this really mean embassies cannot be sued anymore? So Natasha, embassies can still if you have a case pending at a U.S. embassy and they have you in administrative processing for a very, very long time, you can absolutely sue. You could file that mandamus in federal court here in the United States, forcing the State Department to take that next move in your case and get it moving. Okay, but so that's still there. You still have that ability to do that. The case had more to do with the right of a U.S. citizen spouse, if this is the right case. It's been a long day and I was out there in the sun burning up doing all this logistical stuff. So I think this is the Munoz case, where the wife, the U.S. citizen now, the U.S. citizen spouse asserts that she has a fundamental right to marriage, which is true under our Constitution, and that she also has the fundamental right to live in the United States with her spouse, her foreigner spouse, despite the fact that a U.S. embassy has said no to the visa for him because they had serious security concerns about him and they didn't think that he is eligible for the green card. She lost that argument. The Supreme Court says that no, you don't have that fundamental right to live in the United States with a foreigner spouse. You could go to his country in El Salvador and live with him there. Okay. And then secondarily, what it says is that, we foreigners cannot sue the U.S. government and demand that their visa refusal be looked at. Their visa, this is the consular nonreviewability doctrine that the Supreme Court says this has been around forever. We're not going to touch it. We still don't want foreigners having that right to come into federal court here in the United States and sue for the visa being refused and demanding that their case be reviewed by a federal judge. We're just not going to do that. We don't have we're just not going to do it. We don't have the capacity for that. So that's what that Supreme Court's case says here. Mary wants me to discuss DACA. So Mary, there is nothing significantly new related to DACA aside from a couple of weeks ago, June 18th, when President Biden said that Dreamers, DACA holders, and other undocumented immigrants who have a college degree and a job offer will be able to leave the U.S. and go to a U.S. embassy and apply for a waiver, submit a waiver of whatever their inadmissibility problem is, and come back with that work visa and be here, like with the H-1B visa. That can help people with DACA. Also, what can help them is the new PIP parole in place. That could also help people with DACA as well. So there is nothing else that's very specific to DACA that has been brought to the table. Thank you very much for your question. Janice says that her husband went for a second interview in Kingston, Jamaica. Unfortunately, he was denied, stated that I married too soon or too early. I married too early. SEAC stated that it was sent back to NVC. What is the next step? It sounds, Janice, you should definitely get a consultation with us. We work on these types of cases. It sounds to me like maybe his case started out in a particular category, maybe when he was single, and then it went to the, then he got married, and then it changed, his category changed. That's one possibility. I don't know. The second possibility is that if there was a marriage that occurred too early, it's because someone was still married to someone else. A divorce had not finalized before the new marriage took place. Whatever the case might be, and so therefore the I-130 shouldn't have been approved to begin with. Let's unpack this together behind closed doors, okay? I'm intrigued by what happened here, and we would want to be able to help you and your husband. So book a consultation. Thank you very much. While waiting for an interview for adjustment of status, is it safe to travel locally? I think so. I wouldn't get on a bus. I wouldn't get on a Greyhound, because those are the stories that come to us, which people were asked for ID. But you should be fine. You're seeking status here in the United States anyway. I don't think you should be fearful even about going on an Amtrak or Greyhound. All right, let's see. North Carolina is in the house. Thank you very much. Patrick says, my question for you is, I'm married to a U.S. citizen. Can I apply for parole? Have 10 years in the U.S.? If you've been, so 10 years residency in the U.S. a minimum, and you're married to a U.S. citizen as of June 18th, 2024, you entered the United States illegally. Okay, I'm not even going to use the fancy words. I'm just going to say illegally. That's what it really requires. Okay, if you enter it that way, I'm starting to get hot, guys, because I'm overdrive. Woo. So If you entered illegally and you meet the other requirements, then PIP could potentially be something that could help you. Okay? Thank you. Freedom now, freedom now, freedom now. Someone says, what is the difference between removal proceedings and a removal order? So, a removal order is at the very end of the proceedings, if you did not win your case and the judge orders you deported. That's what that is. Case is over, judge issued his or her order, and that's that. If someone was in removal proceedings in 1999 and they married in 2004, still eligible for PIP. So long as you're still married, or are you still married? We've been getting some consultations in which people say things like, "I used to be married." Well, if you used to be married and you're not married anymore to that U.S. citizen, well, PIP is not going to work for you. Or they say things to us in consultations like, I'm married, but I haven't seen her in years. Well, that's not going to work. PIP won't work for you. Or I'm married and we are not together living in the same house anymore. She left me last year. Well, PIP won't help you either, not unless somehow your relationship, you guys genuinely reconcile, because for PIP, you will need that spouse. Okay. Freedom now, King. Freedom now. Thank you. Freedom now. I have consultations starting in 10 minutes. So let's keep going. Thank you. Thank you. Let's see if I could skip over, because I see some people are asking. I've answered a question, then they ask a second one. Thank you. Freedom now. I see someone with a C1D entry. Approved I-130. You were told you cannot adjust your status. There is a bar to adjustment of status for individuals who had gotten a crew workers visa. The government, there are, in very, very, very limited circumstances can adjustment occur, but an attorney will need to see whether you meet that narrow window. But if otherwise, for most people, they're not eligible to adjust their status. They would have to do a waiver and then go back to the U.S. Embassy to finish their process if they entered with the crewman's visa. King says, can you get a green card through your U.S. citizen child under 21? No, the child must be at least 21 years old. At least 21 years old. Someone says, if you have an asylum case that was administratively closed in the U.S., 30 years, married to a U.S. citizen for 4 years, and you have a work permit, you have an approved I-130 and submitted 601A, entered without inspection, PIP can help. I think let's have a consultation and talk about that. It's possible that PIP could help you. It depends on, you said that you entered without inspection, so you have that check. You have been married for 4 years now, check. You have been in the United States for a very long time, check. But you're still in removal, just so you know. You're still in removal, and because you're still in removal, you will need to get your PIP approved. You already have an I-130, so that's good. The next step, I think, would be to recalendar your case in court. Once you have gotten your PIP approval, I would seek recalendering in termination, really, at that point of your removal case, so that you could then apply for adjustment of status under PIP. Thank you so much for that. I got a super chat. Question is, Marco says, I'm married with a citizen and I enter legally with a visa. So Marco, if you entered legally with your visa, you're not eligible for PIP. You would be eligible for a green card through the normal way of getting a green card, adjustment of status, I-130, I-45, and there you have it. You can get your green card that way, provided that your record, you still have a good record. And if you have some problems on your record, you might be eligible for a waiver to take care of those problems, okay? Thank you for your super chat. Freedom now, freedom now. Thank you. Again, book an appointment if you want to go deeper about your immigration case. Here's a question about Haiti TPS July 1st. Yes, today, by the way, is the registration period for TPS. This says that the question is, can we still apply today or do we need to wait until August? But presence has to be proven as of. I would the July 1st all the way up until I think February, whatever that year is, 2026, I think. I don't know. I don't have that reference point in front of me. That's the registration window. The big issue here is because you're trying to do an initial registration, you're eligible for it, because you were here as of, what is that date? June. What was that new date? June 4th, I think I mentioned, or June 3rd. I mentioned it during my last news video on Friday. You were here in the US as of that date, so you're eligible for the initial registration. Yeah, I wouldn't submit it quite yet. Um, if they're saying that you have to prove presence as of August 4th, that I didn't know about until you just mentioned it. I don't know. But yeah, freedom now, freedom now. I would wait until you get to that presence date, but you're eligible for it. So congratulations on that. Thank you. Let's see. Someone is asking any news on the I-601 processing time. Processing time vary for the I-601 waiver. We see it happen in a few months, depending on what kind of case we paired it with, depending on if the client is here in the United States or abroad. The processing times do vary. Someone says that, are you hiring currently? I'm really good at filing documents, and my major is computer science. I also speak 5 languages. So, Coda, I know that we do have some back office support positions that we're trying to fill right now. If anyone is interested in being considered for any job at McBean Law, you could always check Indeed to see what we have currently posted. You could also submit your resume to jobs@mcbeanlaw.com, jobs@mcbeanlaw.com. We're always looking for a good resume, so you can do it that way. Thank you. Freedom Now, Lilith. Thank you for being with me. Let's see what other questions I could answer. So let's see. I lived in New York City for 30 years. I have 4 past names, okay? And I didn't something about crimes. I have 4 U.S. citizen children. Am I eligible for adjustment of status in New York City? I don't know, maybe. It depends on what's on your record. You mentioned that, okay, you don't have any crimes, but you have some aliases that you have used in the past. You have American children. Who would be the petitioner for you? Are any of your children at least 21 or over? Are you married to a U.S. citizen? You should have a consultation, Best Big Rose, so that we can go a little deeper to see whether adjustment of status is something that you can do. It depends on what you did with those names as well. And if there's any misrepresentation over the years, have you submitted any documents to USCIS in one of those aliases and tried to get a green card under the alias? Things like that will be a big problem, okay? Thank you, Freedom Now. Freedom Now. Someone says, I love your work. I can't wait to start working with you and dealing with my case. Awesome. Come on in. Come on in. Our team is really wonderful to work with. Freedom Now. Let's see if I could take, let's see if I could do, okay, another super chat before I go. I'm married with a citizen. I'm married with a citizen, and I entered the legal entry. I answered that already. From training, okay. I don't see what the question is there, okay? I'm sorry. I never get any tickets since I've been here. Marco, I answered this question earlier about your trying to get a green card through the spouse. Someone is asking a question about Chevron. Will the Supreme Court ruling on the Chevron reversal affect DACA? I don't really think so. I think that the Chevron decision, litigation, I think will begin popping up more so at least the early litigation will be from corporations challenging certain agency rulings in the past, because that's about money. So that's where the litigation will happen, from big companies that have the money to really litigate these rules that stand in their way of making more money, making more profit. DACA, on the other hand, is more for like a social policy type of agenda, so to speak. And so I just don't see that it's going to be that top of the priority list for anyone to really challenge under the Chevron ruling. Friends, I've got to get going. I'm going to try to get back before you guys again for another live session, maybe tomorrow if things ease up with us a little bit. It's so hectic right now. Thank you for understanding. Guys, follow us, follow me on Instagram, on TikTok, where sometimes I show some random stuff from my life. But more importantly, I share more short videos and other things like that. So follow me on TikTok and Instagram and Facebook. Call our office at 888-462-4006 to book an appointment with an attorney. Consultation fees begin at $250 for my colleagues and $300 with me. Now is a great time to work with us. Now is a great time for immigration. So we cannot wait to see you soon. But be on standby. I'm going to try to do another live session with you guys, maybe tomorrow or Wednesday. So I will see you soon. Have a great rest of your day, friends. Bye-bye.